Assalamu alaikum and a very good evening to you all. Welcome to our weekly show Legal Advice. My name is Ahmed Malik. I'm a practicing barrister and I have with me today my colleague Barrister Fiaz Hussain, who is also a practicing barrister. Both of us practice from Westminster Law Chambers. The viewers, you might have seen us last week or week before. This is our third show and hopefully you will see us in future. Well, to start with, I would like to remind everyone to join us by sending your questions. You can you can text your questions on the telephone number you can see on screen, but I'll say it again anyway, which is 0771 347 1905. And please do not call us, just send us a text, then we can read and answer your questions. At the same time, you can comment, send your question on Facebook by typing your question on comments. We will then be able to read and answer your questions. Like before, we will be speaking both in English as well as some part in Bangla. My colleague who doesn't speak English, but he does speak other languages like Urdu, Hindi. I will try to answer, well, both of us, we will try our best to respond to your questions within the very short amount of time that we have. We have about, say, just under 1 hour. Yes. So let's make a start. I think what we will do is, as our heading is, our topic is general legal advice, and the reason for it, viewers, is that we would like to cover as many questions as possible, and because we cover wide areas of law between us. If I just say a few of the areas which we would be able to assist you with are, firstly, immigration, of course, immigration law. If you have an issue with immigration problem, you have immigration problem, or somebody you know who has an immigration problem, please feel free to contact us. We will try our best to answer your questions. At the same time, which are the more serious matters like court cases, if there is a court case to do with anything really, apart from crime, we do not intend to touch on crime. Although I have practiced criminal law at some point, I have the general knowledge, but I do not practice criminal law anymore. I do practice civil law, and both of us practice civil law. So any aspect of civil litigation, any court cases in any court, from county court to the Supreme Court, we would be able to give you some answers to your concern or questions. This can be anything really. I mean, property related matter, money related matter. If you have an issue with the family law, we will be able to help you as well. So Fiaz, this week there has been, in fact last week there has been announcement about changes in immigration rules.
Right.
And I have this week, last few days, I have received a number of calls from a number of my clients. I think I would just to give some brief updates about only just a few updates, because we intend to cover many areas, as we have said. There are fundamental changes which have been with regard to fee increase, which came into effect on the 6th last week, 6th
Right.
of April. The increase has been, say, quite a bit of increase actually. A couple of applications which mostly our clients do. One is if somebody is applying for an extension on of leave, either on human rights grounds, or on family spouse grounds. It was £811 before. It has now been increased to £993.
Right, so nearly £1,000.
No. 993 is more than £100 in the
Yeah.
nearly.
So nearly £1,000.
Nearly, yeah, the fee is now nearly £1,000. It was 811 before. Now, for indefinite leave, that is the killer. It was 1,875 before for indefinite leave to remain. Now it has gone up to £2,297.
My gosh, that is a steep rise.
A steep rise. So those are the main two increases which a lot of people will be affected, I think.
Is the JR fee still the same? Or
I don't think I have. The JR fees are for the upper tribunal
yes.
to decide. I think there hasn't been any changes recently. I am not aware of any changes. If anybody is intending to make an application, you have to be ready with all this money. Home Office are making their money definitely.
Yes.
And how can they justify charging so much money? What do you think?
Well, I suppose thinking of the volume, the amount of applicants that there are per annum, I think the fees in itself just go in the hundreds of thousands, possibly even a million or a million plus collectively.
You see, there is another fee for every applicant, which is health surcharge.
Yes, that was introduced.
That is for if you are applying for limited leave to remain, or if you have come and applying for with a visa and applying for an extension, you still have to pay. Some people have to pay 500, some people have to pay £600.
Oh, so that varies as well. There's no fixed amount.
For further extension, it is about 500. If you are applying for the first time, say seeking an extension of leave on human rights grounds,
Right.
fee 993 and plus £600
Yes.
health surcharge. I'm not really sure if it has gone up. I haven't checked that one. So it's a lot of money. In my view, it's really unjust. But obviously, there was a challenge about the court fee increase. There was a appeal fee. It was 100. When you are appealing against a decision to the first year tribunal, it was £140. Say somebody who applied for asylum or leave to remain on human rights grounds, and their application is refused, you had to pay £140.
Right.
Now it went up to more than £800. I think 800 and something, 40 or something. But there was legal challenge. Plus, after the new Justice Secretary, it was Mr. Before this new Justice Secretary came into her post, there was a previous Mr. Gove, I think. Mr. Gove was
Andrew Gove, yes.
Michael Gove was the Secretary of State for Justice at the time, and he introduced those. But they have now gone down.
Right.
I hope they stay now the same. Anyway, so viewers, if any one of you, anyone who are watching, আপনারা যদি খেয়ে দেখরা, আমরা যদি কোনো question থাকে বাংলাতে কইতাম পারবো answer, it's not a problem. আর যারা আগে জিজ্ঞেসেন আমরা ডিসকাশনের ফাঁকে আমরা মাঝে মাঝে আপনাদের সাথে আমরা নতুন কোয়েশ্চন শেয়ার করবো, আগর কোয়েশ্চন যেগুলো আমার কাছে টেক্সট হয়ে আইছে ওগুলোরও কিছু আনসার দিব। Fiaz, last week I think we were talking about someone let's deal with one question. Somebody wanted to know he was owed money because of some breakdown of relationship with his partner. He wanted to try to recover. I think it's about 25 or 30,000 pound, and he's trying to recover. He just wanted us not to mention his details. Of course, we will not mention your details. Whatever questions are being asked, we shall never reveal the questioner's details. So please feel free to ask us. We can assure you. Yeah, he wanted to know where to start. How does he go about?
Is this a business dispute with his
Yeah,
business partner?
business. Yeah, his business partner. They started a small business, and the business partner, he was managing everything. Then he suddenly he's been asked not to go there to the business. It's a small takeaway restaurant, and not to contact him. He said, "If I make any money, I will let you know." This is the attitude his partner is showing.
Right.
Now he wants to know how does he go about. He consulted a firm of solicitors, and he was very. He got shocked to hear the possible cost that he was quoted. So how do we help this person?
Well, the first thing I think in instances like this, just to give an outline, we first of all to ask whether there was any written agreement, a partnership agreement, and that would establish his responsibility as well as the partner's responsibilities as well. And then secondly, we will have to just inquire as to who was responsible for what, and in a situation like this where there is a dispute, what actually happened and what was the breakdown, or what was the reasoning for the dispute, for the partnership to break down. Also, this individual, he put forward funds?
Yes, he is equal partner, 50-50 basis. That's what the message says. Yeah.
Right, but did he put any funds in it, or
He did pay. The business started, the both of them together, because he is unable to give time or work in the business.
He's a silent partner.
He has another. Yeah, he is another. Basically his investment.
Right.
He just want to know how he can recover his investment, or he just want to get out of it.
Right. I mean, in a situation again, providing all the background checks in terms of source of income, and he's in a position to have paid that, and he can show all of that, then it would be a simple letter. That's what I would do in the first instance. Write a letter.
Well, I think the pre-action protocol letter that we are required to do as the lawyers. You're right. Say formal demand is required, and then if the person or his partner doesn't really respond positively, then he has no other choice but to
start proceedings
in
county
court. Yeah, but one other thing I have to say, if it is sometimes very difficult to bring people to make your partner listen when the relationship breaks down.
Indeed.
People have ego problem. People have a lot of people that's unreasonable. They don't want to. You have to force them to talk to you even, and the only way you can force them to talk to you is just to commence proceedings.
Yes, unfortunately.
Very unfortunately, but I would say to the person, the questioner, that you will need, I'm afraid, to spend some money if you are not legally, of course, you don't have legal knowledge and procedure. So this is something you can talk to a lawyer and try to agree an amount, maybe based on, rather than, I think the firm you mentioned, you're going to a very the firm of solicitor who is a medium range, their hourly rate is quite expensive as well. So I would say, rather than going through an hourly rate, talk to a community solicitor or barrister and try to agree a fee that you can afford. Say, rather than hourly, just to say, okay, ask them how much it would cost to send a letter before claim, and then second, if this doesn't work, ask them how much it would cost to prepare your particulars of claim and issue the claim on your behalf. So get a breakdown and agree work on fixed fee. That is going to be more beneficial to you. Often you will find smaller firms would be more suitable for your purpose. And then, a lot of people have the think that if I go to a big firm of lawyer, if they just send one letter, that will do the trick, because of the name and all this. But it doesn't work like this, I'm afraid. যারা মনে করেন যে সাধারণ সলিসিটার বা বড় ফার্ম সলিসিটার গিয়ারি একটা লেখাইলেও তার কাছ থেকে খাম হয়ে যাব, আর পয়সা দিলাইলা 200-300 পাউন্ড বা 500 পাউন্ড 1000 পাউন্ড, এরকম খাম হয় না সাধারণত, এক সিটি খামে হয় না। অনেক সময় এক সিটি লাগিয়া আপনার আরও অনেকবার যাওয়া লাগবো, আরও অনেক কাম করা লাগবো, সেগুলো দেখবা একটা 5000 পাউন্ডের বিল হয়ে গেছে, 10,000 পাউন্ডের বিল হয়ে গেছে। তো আমার তখন খাজনা থেকে বাজনা বড় হয়ে যাব, 25,000 পাউন্ড খাবার করতে গিয়া আপনি দেখবা আপনার 20,000 পাউন্ড কষ্ট হয়ে গেছে এবং আপনি বাধ্য হয়ে যাবা তখন পয়সা দিতে। তো ভিউয়ার সকল যারা বিশেষ করে বাংলাদেশি যারা ভিউয়ার্স আছেন, অনেকে এই সম্পর্কে ধারণা নাই, আইডিয়া নাই, আপনার অবগতি লাগে কইরাম আমি যে বেস্ট হইব গিয়া সুটো ফার্মগুলোর মাধ্যমে যারা কম্পিটেন্ট এক্সপিরিয়েন্সড লয়ার আছেন তারার লগে কাম করুক। যখন আপনার অ্যামাউন্ট স্মল হইব, হ্যাঁ যদি কোনো কমপ্লেক্স কোনো ম্যাটার হয়, ইফ দ্যার ইজ এ ভেরি কমপ্লেক্স ইস্যু which require expertise, for example corporate matters, something which everybody or something like professional negligence, or something like probate, contentious probate matters, those matters, yes, you need very competent experienced lawyers for your own interest. So even those matters you can find very competent, experienced barristers who nowadays work under direct access.
Yes.
I am direct access qualified, and I often see my clients without solicitors anyway. And this is beneficial to my clients. They just have to pay one person rather than paying. If you come to me through a firm of solicitors, you have to pay twice, which is not very beneficial to the client.
Indeed.
There are many direct access barristers now available. If you just visit the Bar Council directory or even Google searches, search on Google, you will find it. But anyway, but some good solicitors are there as well who has got experience and who would be able to assist you in a small claim like this.
Yes.
I hope the gentleman who sent the question, he will have some idea from what I have discussed.
Yes.
Do you want to add something else?
Well, I mean, ideally, if the cost is an issue, then what Mr. Malik, just to echo what Mr. Malik said, is direct access seems to be a sensible route, working on a fixed cost basis, and initial conference seems to be the best way forward as well.
Yes. Anyway, so this is just one question which has taken us to our first break. I think 15 minutes we have spent. Inshallah, we'll come back to you soon after just a small break. So please stay with us. Thank you.
আজকে থেকে ইগোর আমার ইগোর অধিকার আমার বেশি, আমি হকর বড়।
তোমরা আমারে শান্তি মতো মরবার দিতায় না, বুঝছি। ব্যারিস্টার মালিক সাহেবরে খবর দাও, উইল বানাইতাম।
দেখলা তো উইল বানাইলে কি অবস্থা হয়, আজকেই উইল বানাও, টাইম ওয়েস্ট করবা না।
ইমন,
What are you doing here?
ইমনডে দেখতে পাইছি।
It's best you just stay away from us.
ইমনডে একবারটা দেখতে দেও, একবার।
Breakdown of marriage affects parents and children. Barrister Malik and his expert team of lawyers can act to elevate pain and stress. Westminster Law Chambers.
পুলিশ রে জিয়াবা, তোর মা আমারে দিবার লাগে আইছে। পুলিশের মা, আমি আইয়ার।
আজকে থেকে ইগোর আমার ইগোর অধিকার আমার বেশি, আমি হকর বড়।
তোমরা আমারে শান্তি মতো মরবার দিতায় না, বুঝছি। ব্যারিস্টার মালিক সাহেবরে খবর দাও, উইল বানাইতাম।
দেখলা তো উইল বানাইলে কি অবস্থা হয়, আজকেই উইল বানাও, টাইম ওয়েস্ট করবা না।
ইমন,
What are you doing here?
ইমনডে দেখতে পাইছি
It's best you just stay away from us.
ইমনডে একবারটা দেখতে দেও একবার
Breakdown of marriage affects parents and children. Barrister Malik and his expert team of lawyers can act to elevate pain and stress. Westminster Law Chambers.
Dear viewers, we are back again with you. Please, thanks for being with us this evening. We are two barristers here to deal with your legal problems. Myself, Ahmed Malik, and my colleague Fiaz Hussain. Both of us are practicing barristers from Westminster Law Chambers. We had a question from someone just a little while ago. He wanted, I think his question is not very clear. He came as a student and he wanted to know if he could seek asylum possibly. This may be the question, is not very clear. Yes, let me just tell you about the rule about asylum briefly. Yeah, if somebody comes to the UK in any manner, it doesn't really matter in what manner you come. A lot of people come illegally even, and you have a good reasons to apply for asylum. You can apply for asylum to stay in the UK. Asylum means that your life, you think that your life is not safe. আপনি মনে করেন আপনার লাইফ সেফ নাই, নিরাপদ নাই আপনার দেশে, whatever country you come from, you feel that you cannot go back to your own country, maybe for political reasons, maybe for any other reasons. There are two types of asylum. One is something on convention ground under the Geneva Convention, UN Convention is known as, and UK government has an obligation to provide people shelter and to a safe place to live, so long as their fear continues. And that means that যদি বাংলাদেশি কেউ in a similar situation sorry, in between I will talk to in Bangla as well.
Of course.
Anyway, Bangladesh looks like the person who sent the question is Bangladeshi. Bangladeshi কেউ যদি সেম সিচুয়েশন থাকেন, আপনার যদি জানো নিরাপত্তার অভাব বোধ করেন, ইয়েস মেবি পলিটিক্যাল কারণে, আমরা জানি বাংলাদেশের পলিটিক্যাল রিজন আছে অনেকগুলা, বিকজ অফ দি লটস অফ kidnapping and killing and all this, the war they show. For all these reasons, the political opponent দ্বারা যদি আপনি মনে করেন আপনি আপনার লাইফ you will be persecuted আর প্রুভ করতে পারেন, then of course you can apply. Generally application system হইল গিয়া হোম অফিসে যাওয়া লাগে, কাগজপত্র ডকুমেন্টস দিয়ে হোম অফিসে যাওয়া লাগে, গিয়া অ্যাপ্লিকেশন করা লাগে। আপনার যদি লয়ার থাকেন, লয়ারের মাধ্যমেও আপনি তার হোম অফিসের লগে আগে যোগাযোগ করতে পারেন, তারপরে আপনি সপ্তাহ রেডি হইয়া আপনি হোম অফিসে যাওয়া লাগবে। বেস্ট হইব গিয়া অ্যাডভাইস লইয়া প্রিপেয়ার হইয়া তারপরে যাওয়াটা বেটার। All I would say that once you have, if anyone they fear that they have their life would be in danger in their own country, they can seek asylum. Okay, and of course another way it can be done is if somebody feels that they would maybe killed if they go back to under Article 2, right to life.
Yes.
And of course, if you feel that you will be subjected to inhuman or degrading treatment, Article
persecution.
Article 3, then of course those also you can apply at the same time. Okay, so these areas are quite complex areas of law. যদি স্পেসিফিক যদি কোনো কোয়েশ্চন থাকে, প্লিজ feel free to question us. So we will try to assist you as much as we can. I wanted to mention something about child arrangement order, because I had a question last week. A gentleman, he wants to he hasn't seen his children for a while. He's been separated from his wife for some reasons, unfortunately. Although he's still married, his wife doesn't allow him to see the children. Now, what should he do? How can we help him?
Proceedings?
No proceedings are pending at the moment.
Right. What I would advise him is to make an application for a child arrangement order, and in that case, the court would look at the possible circumstances. There are various agencies who will be involved, for example, CAFCAS, that will do what is called a Section 7 report to ensure that the safety and well-being of the children will not be compromised. And in an instance like this, even though there is an acrimonious relationship, but the court nevertheless has a sensible approach and will of course realise and acknowledge that both parents have parental responsibilities, and the fact that the mother is depriving her husband from seeing her children would be a factor that would weigh in the father's position. So in a nutshell, he should make an application for a child arrangements order.
Yes, I think I would say though, let consult a lawyer, or even if you have, if you are unable to afford legal fee, go to some. There are free advice centers available. Some law centers also advise people on, give preliminary legal advice. You need to formally approach your partner. You need to write a letter or through your lawyer, and to make her aware that you have as much rights to have regular contact with your children as your partner. You have the legal rights to see your children. A father is only denied legal the contact with the children if he has been cruel, or if his contact with the children would not be beneficial.
Yes.
It would affect the children, or it wouldn't be in the children's best interest.
Yes. The CAFCAS will do an
Now,
investigation.
normally what happens is that the court try to, and then you have to complete an application. These things require legal knowledge, of course. But if somebody who doesn't want to, who can read and write fluently, and have general understanding of English, if they can try to do it themselves, even by completing the relevant forms, and you just have to write to saying why you want to seek contact with the children, and what kind of contact you want. Sometimes the communications totally break down.
Yes.
No contact whatsoever. There are some direct contact, there are some indirect contacts also. So once you apply to the court, there will be something called family dispute resolution hearing, the first hearing, where your wife or partner has to come to court, you have to go to court, and then both of you, the judge will try, if the lawyer's there, if you don't have a lawyer, you can represent yourself, you can go alone, and the judge will try to find a common a solution by talking to both parties and see if the matter can be resolved from there and then. And if this cannot be resolved, then judge will give directions how to deal with this application. And then, of course, often the CAFCAS means a court welfare officer is appointed by the court. There is a department, and there are a lot of qualified welfare officers. They are appointed, and they will be filing a report, independent report, for the court. And those officers, they will be talking to both parties, husband and wife, and the children themselves. Well, of course, it depends on the children's age as well. There are some children who are very young, who are not able to give an opinion. It is difficult, but those children who are able to speak, the officers often try to speak to them and just to know their wishes. So this is also something can be done individually, but it is advisable that you find a lawyer who would be able to assist you. These things cannot be done overnight. They take some time. I know when a family breaks down, the relationship between a couple breaks down, often the party who is living with the children, they try to often
access.
become difficult often, for your own reasons. Often, sometimes it is a financial reason, sometimes for behavioral, reasons. So, I would say to people that the court doesn't really like to use the children as pawn. Trying to use the children to get at your partner.
Yes.
যারা মা হোক আর বাপ হোক যারা বাচ্চাদের ইউজ করেন যেমন আপনার সম্পর্ক নষ্ট হয়ে গেছে প্রতিশোধ নেওয়ার লাগি রিভেঞ্জ নেওয়ার লাগি আপনার পার্টনারের এগেনস্টে বাচ্চাদের ইউজ করেন কন্ট্যাক্ট দেখায় না এটা কোর্টে লাইক করে না একটা যা যখন একটা লাইক করে না তারা একটা আপনার নিজের ক্ষতি হইব আলটিমেটলি যা যখন দেখতে চায় অনেক সময় বাচ্চাতে মা বাবার সাথে কন্ট্যাক্ট রাখতে চায় কারণ যদিও আপনার লগে আপনার হয়তো সম্পর্ক খারাপ হয়ে গেছে কিন্তু বাচ্চাদের লগে কিন্তু মা বাবার সম্পর্ক ঠিকইও থাকে এবং বাচ্চাদেরা ছোটো থাকলে তারা জানতে তারা বাপর লগেও থাকতে চায় মার লগেও থাকতে চায় এবং তারা বাপর কোম্পানিও এনজয় করে এবং জানতে অনেক সময় আপনার ডরাইয়া বয় করিয়া হইতে পারে না তো দিজ আর দ্য থিংস দ্যাট প্যারেন্টস আপনার আন্ডারস্ট্যান্ড করা দরকার কারণ বাচ্চারা যখন বড় হয় এরকম সিচুয়েশনও তখন ফরে বড়ই হারলে ফরে মা বাপরে খুব টেল অফ করবো মা বাপরে দুষবো এই সম্পর্কটা একবারে টোটালি নষ্ট করবা লাগে সো আমি আই উড রিকোয়েস্ট মাই ভিউয়ার্স টু বি ভেরি কনসিডারেট ইন দিস রেসপেক্ট টু শো be sympathetic, have a sympathetic approach. You have to think of your own children.
Yeah. You have to operate with the children's best interest at heart and mind.
Yeah, that's what it is. Anyway, so that was a question about contract. I mean, we will be able to give more advice or information in this area. If please feel free to send us your message again. Okay. Now, one thing I would like to mention today. I think our time is really going very fast, Fiaz. Somebody there was the question last week. Someone, that landlord has changed the lock, and they wanted to know that there were some arrears of rent because the tenant was away, and what they did, there was arrears of rent for about 2 weeks, and the landlord came and changed the lock, and when he came back he couldn't really get entry to the property, and then he contacted the landlord say, do whatever you like, I'm not going to let you in unless you pay my money. Now what can be done in this situation?
Is this a residential?
It's a residential property, yeah.
Yes, well, I mean, clearly the landlord is acted in defiance of the law. Even though there are genuine arrears, it's not down to the landlord and the court, and the law does protect the tenant. You cannot just simply change the locks and prevent entry. And there's possible criminal implications for the landlord in this respect. In the meantime, immediately perhaps an injunction can take place for access, but the tenant will inevitably have to issue some sort of proceedings in the county court for this to be resolved.
Well, firstly, if I may just add that there are protection from harassment. This is a clear harassment, whatever
Yes.
has happened in this case.
The Protection from Eviction Act will kick in.
Yeah, the landlord must be aware of this law, that he will be penalized by the court heavily. This tenant can get an injunction, as you said rightly, and also sue the landlord for damages, for compensation.
Yes.
And landlord has no defense. Being in arrears of rent, yes, it is possible. You have to follow the rules. If a tenant has been in arrears of rent for 14 days, for the past 2 months, I think, isn't it?
It's 2 months. You have to have at least 8 weeks.
Yeah.
Depends on which route they're going for. They're going for that
Yeah, you can. Sorry.
accelerated procedure.
Yeah. What we do is, just I think I've been told that our time is coming to an end, so we'll just take couple of minutes, and we will just continue hopefully next week. Yes, if a tenant has been, as you said, has been in arrears of rent for 2 months, then you can give him a notice for 2 weeks, 14 days notice to get out. And then you can get a mandatory possession order easily.
Yes.
Now you cannot take law into your own hands, because you have your tenants, are in a tenancy in area. Law protects the tenant in this situation, and landlord should not victimize or bully the tenant in a situation, in a manner like this. So therefore, our advice to the person who questioned us, sent the question, that you can get an injunction immediately, unless you're the best thing would be just to get a letter sent out by your solicitor, asking the landlord to allow you access immediately. And longer you are out of the property, the more compensation you can get. But you must send a letter. Maybe that will solve the problem. Maybe this landlord is not aware of his legal obligations, and he doesn't know. He's being a bit daft. So in my view, if after writing the letter, if the problem is not solved, then you must apply for injunction. Of course, you can get your cost in this situation against the landlord. Court normally orders cost, if they will also order compensation, and I have succeeded in cases like this before. Anyway, I think we would have to finish now. It's Maghrib time as well, it's approaching, and dear viewers, time goes so quickly, and inshallah we hope to see you again next week. And next week we will try to start our program on time at 7 o'clock rather than delayed. Thank you for watching us. Thank you for being with us. And please keep sending your questions by text and also by commenting on Facebook. Hopefully see you again next week. Stay well. Assalamu alaikum.
Thank you.